Just so you know, you all have new agendas at your place. Thank you so much. Hi, good morning. Okay, welcome. A new week in Senate Economic Development, Housing and General Affairs. It is March 18th. I hope you all had fabulous Irish soda yesterday and Irish tea. And that you are refreshed and ready to rock and roll here because we have a full week. So to continue to address some of the issues that remain in our labor bill today, and tomorrow we're going to address some housing issues that remain because we're looking at possible amendments to the labor bill we voted at last week. We are looking at possible amendments to S-125. It now has a number. And we're going to begin further discussing the proposal that we allow the Assistant Attorney General to have the right to collectively bargain. And we're going to begin with Sarah London, the Chief Assistant Attorney General at the AG's office. Welcome.
Thank you.
I don't think you've been in this committee for a while.
I haven't. I still think that this has been Saluzzi's committees.
Oh my God. That's quite a while. And he is in on a regular basis. I'm happy to let you know. And actually, he was complimentary of our work last week. So he continues to be very engaged.
Excellent.
So because you haven't been here, I think we should probably introduce ourselves.
Thank you.
Hi, Sarah. I'm Chittenden and I represent the southeast area of Chittenden County.
And Keisha Ram Hinsdale, who will get to us, I hope, soon, and who represents the same district, Allison Clarkson, Windsor District, Randy Brock, Franklin County. He'll be here in a sec, we hope.
Good morning, sir. Dave Weeks, representing Wellesley Council.
And you are.
And I am. So I'm Sarah London. I am the Chief Assistant Attorney General at the Vermont Attorney General's office. And I am in what is currently the only classified lawyer position in all of the executive branch of state government. And the position was created by statute, possibly in the 1940s, but at least in the 1950s. And at that time, the legislature decided that it wanted one lawyer position in the Attorney General's office that would not necessarily turn over with an elected Attorney General. So it's a unique position. 3 people have held the position since it was created in the 1940s or 50s. One of those is Justice Louis Peck. One of them is Bill Griffin, and I am the 3rd. So that's one model of legal services in state government. Again, it's a unique position. If our interest is in making AAGs more permanent employees, some of the statutes related to my position may be a model on that. And otherwise, I'm here to talk about the multiple statutes, including those outside of the State Employees Labor Relations Act, that the committee will want to look at and make sure we reconcile if we're trying to provide for collective bargaining of AAGs. At the highest level, and I think I only may have 15 minutes of your time. If I go too fast, let me know. Please ask questions as we go. I'll try to leave time for questions. I think everyone has this kind of one-page handout with an attachment on it. And as
Does it have an attachment?
The back side. Yes. So what I tried to do on the back was map the non-manager AAG salaries. If our focus is salaries, I hope this is helpful. I tried to map the non-manager AAG salaries against the steps attached to the current collective bargaining agreement for the deputy state's attorneys, but I'll get to that in a bit. But I'll try to talk about some of the legal and operational considerations that are unique to the Attorney General's office.
We introduced you in absentia. Randy Brock.
Nice to see you. So I was just explaining, so my position is unique by statute in that it's the only considered classified lawyer in the executive branch of state government, and that the position that was created by statute, at least going back to the 1950s. There are other statutes that the committee will want to address if we want to provide for collective bargaining. So certainly taking a look at my position may be an option. And then the Attorney General's authority over Assistant Attorneys General is also a long-standing statute, and that's in 3 VSA 153. So those are the statutes that talk about the obligations and responsibilities of the Attorney General. So that statute also goes back for many, many years. And it provides several things. It provides that AAGs currently serve at the pleasure of the Attorney General. And that may make sense as a policy matter. Maybe we like the governor's cabinet, an extended cabinet. We want AAGs to potentially turn over with a newly elected Attorney General. In addition to serving at the pleasure of the Attorney General, what 3 VSA 153 does is define how salaries are set. And so by statute right now, salaries of AAGs are set by the Attorney General in consultation with the governor. And that in consultation with the governor is important because this relates to if we want to have collective bargaining of AAGs, who should be their employer? Do we want the Attorney General to still be the employer of AAGs? Or do we want to give that entirely over to the governor? This is a pretty significant possible change to the Attorney General's office. These are all things the legislature can do. There is no other structure in state government and no other structure in the public sector of Vermont like the Attorney General's office in that it involves the interconnectedness of two elected officials, the Attorney General and the governor. And I'll get to more information on that. But as I go through each of these points, I just want us to keep in mind that when we think about, okay, well, maybe we can delegate some of this to the Vermont Labor Relations Board. Some of this can just be worked out through that process. So we're talking about litigation as opposed to legislation. And litigation generally takes longer than legislation. And it's also much more expensive. So we would need to make sure the state is represented. And I don't expect we would ask AAGs to litigate the scope of collective bargaining of AAGs. So we need to figure out who's going to represent the state in this litigation at the Vermont Labor Relations Board. And it may also make sense to think about how long is this going to take? How many months or years might that sort of process take? So some of this, it may be helpful to look to the model going on. So I was just talking about some of the points that I'm going to make here today, the legal considerations, the policy considerations of who should be the employer of AAGs versus whether it be the Attorney General or the governor. If we want to try to delegate these things to the Labor Relations Board, we might be talking about a relatively long-term litigation process, and litigation at the Vermont Labor Relations Board involves, the hearings and all the evidence and findings the board makes. It is then subject to appeal to the Vermont Supreme Court. And what we just saw in the UVM context, I think just a couple of weeks ago, was the Vermont Supreme Court said, you know what, Labor Board, we're going to send this back to you. We want to see some more findings about the scope of collective bargaining over these UVM students or whatever the group at issue there may be. So it can go back and forth is what I'm saying between the board and the court. And so if our interest is trying to provide collective bargaining as clearly and perhaps as expediently as possible, I would suggest that that is better done via legislation as opposed to litigation. There's a lot of uncertainty with the litigation. And again, there's a lot of expense to the state, especially because I don't expect it would be the AGO handling that litigation. And so the state would likely need to contract for legal services. This also highlights again, so who's speaking for the state? So who is the state? So this goes back to the unique structure of our office. So by statute right now, we treat all lawyers in the executive branch the same. So they're all in the same pay plan. The DHR attorney pay plan applies to AAGs and so-called in-house general counsels and in-house lawyers the same. And by statute, 3 VSA 311, AAGs and non-AAGs are treated the same for purposes of labor law in Vermont. Obviously, the legislature can change that. You can carve up the groups of lawyers how we see fit. When we do that, it's helpful to think about some of the aspects, how do we make those decisions as divide of the groups is one point. And then there is work that is unique to the Attorney General's office, including defense of the state. So the non-discretionary work of our office, a big chunk of our work, unlike any other lawyers in state government, is to defend the state when it is sued. And the state is sued not infrequently. Those matters include cases that are across from the union. And it is not correct to suggest that those are simply the matters at the Vermont Labor Relations Board. Sometimes labor and employment cases are in Superior Court. Sometimes they're in the Supreme Court. Sometimes they're in the federal court. And so I'll get to which parts of our office handle these types of cases, but things that are across from the union are not just the grievances pending at the Labor Relations Board. They can also be Public Record Act requests. They can be litigation about Public Record Act requests. They can be general counseling about labor and employment issues in an agency. Right now, the Attorney General's office is able to assign those types of matters across the office. So where we have an influx in one area of non-discretionary work and maybe we're down in another, we can co-assign those matters across the office. In the context of collective bargaining, we would probably not be able to do that. So we might be talking about some additional resources. But fundamentally, the thing that makes the Attorney General's office, well, there's two things. The defense of the state is one that makes us unique across all state lawyers. And then it's this unique structure. So this is a very colorful chart that you may have seen before. And this is our org chart.
Yes.
But it's to try to highlight the different sources of funds of AAG. So I'll try to do this as simply as possible, but there's basically kind of three categories. I'll contrast this against the deputy state attorneys. So the deputy state attorneys, we're talking about one appropriation that goes to the Department of State's attorneys and sheriffs, and then it's allocated across those 14 different offices, but it's a relatively straight line. This is more what our office looks like for the following reasons. So some AAGs, it's a minority, but some AAGs are funded through the general fund appropriation to the Attorney General's office. Other AAGs are in positions associated with the Attorney General's office. They're in AGO position numbers, but they are funded through 14 different MOUs with our agency payers through what's called IDT, interdepartmental transfer. So we're essentially billing our state agency partners. They voluntarily pay those costs. Sometimes that's a process. Sometimes there's some back and forth there. The third category, and if our focus is on the 10 AAGs who make less than $80,000 a year, this is really important. Many of our personnel are in what are called embedded position numbers. So they serve in position numbers that are assigned to an agency, say the Agency of Human Services, and they are funded through the Agency of Human Services budget. And it just happens to be the case. It's a long-standing practice in our office, but often our least experienced lawyers may start at our Human Services division. It's a great place to kind of cut your teeth in a certain type of case, and then people end up moving around the office. So if our focus is salaries, and we can look at this back, the second page of this handout when we get there, but if our focus is, say, the 10 people that make less than 80,000, we really want to make sure we're accounting for how collective bargaining would work for those AHS positions. The Attorney General does not control the existence of those positions and does not control the funds for those positions. So then we want to think about, okay, so if we have collective bargaining, how do we make sure we've got an employer at that bargaining table who can make good on what is bargained? And that's where I would suggest you will likely need to include the governor as an employer of AAGs. Now, a prior draft version I saw was to just add AAGs in the definition of a state employee in SELRA. If we do that, we're taking the Attorney General out of the equation because the Attorney General is not an employer under SELRA right now. Again, the legislature can choose to do that. You can take the AAGs away from the Attorney General. That is a significant structural change. Another approach could be what I think would be new to Vermont, to have two separately elected state officials serve as the employer for purposes of collective bargaining. I think all this is possible. Vermont hasn't seen it, to my knowledge. And
Just,
this
let
is-
me just interrupt you there. That you mean the governor, going back to your initial comments, that the governor and the AG
would
employ them both now. Current,
they both set the salaries.
they both set them
Now
down.
by statute, so that's 3 VSA 153. So if you want to model that approach in the context of collective bargaining, we would probably be talking about creating a new employer structure in CELRA to have both the attorney general and the governor serve. Now, what are the logistics of that? We don't know. There's a lot of unknowns there. There is no other employer for purposes of collective bargaining in Vermont that is two separately elected officials. All of this could work, but it's an area that I suggest we take the time to figure out what it's going to look like. And if we are trying to leave some of these decisions to the labor board, I'm not sure that these are decisions the labor board can necessarily make. And I expect that the clearest and most efficient and certainly the more cost-effective way to do it would be by legislation as opposed to litigation. So I know that was a lot to start. I'm having to take a pause there. If there
Take a moment, I think we have a question here.
Hi, Sarah. Sorry if I missed this. Honestly, the more I hear about this situation, the more I feel like these are folks who do need a seat at the table because this org chart seems to demonstrate how lost they get in, how being in different pockets and, coordinated and supervised in different ways. I'm feeling like, these are folks who need a voice and a way to collectively come together. You're kind of getting at my question at the end. I think calling the Vermont Labor Relations Board litigation, is fuzzy a little bit because I think that it can be a very cordial technical process. Have you looked at other states that have AAGs that are organized I think parameters like 2 employers might be helpful, and we might have to come back next year if there's something that's more legislative than VLRB functions. But what are you afraid of with it going into litigation in the Vermont Labor Relations?
So the uncertainty for all of us at the Attorney General's office. So while that litigation is pending, we have to figure out who's going to speak for the state and how do we assign this work while that litigation is pending. I think it is realistic to expect the litigation will be pending for at least several months. And it is possible it could be pending for years if there is an appeal to the Vermont Supreme Court. So again, we're talking about litigation where the state might be a combination of the Attorney General and the governor. We'll have to figure out who's going to speak for that entity and how does that work. That will involve cost, because again, I don't expect we would ask AAGs to litigate it. So it is a litigation process. On your first point, I so appreciate that recognition of the office. And if I may, I just want to point out, so it is an outstanding office to work at, the Attorney General's office. We have outstanding retention. Some of this is reflected in our salaries. Our largest volume of practitioners are at the highest end of our pay scale. We have a number of very experienced attorneys. So we have folks who have been practicing law since the 1980s. So we are also the largest collection of lawyers of any entity in Vermont, public or private. So we are the largest collection of public sector lawyers, and we like to call ourselves the largest law firm in the state. There is no private law firm that has this many lawyers in Vermont. I would say we benefit tremendously from that size. And on the salary front, I would suggest we also benefit tremendously from treating 100 lawyers the same. So we are administering the attorney pay plan across the largest group of lawyers in Vermont. When we hire from agencies, and we regularly hire folks from other agencies, sometimes that person is at a lower salary than we would pay them as an AAG. And sometimes they're at a higher salary than we would pay them as an AAG. We are very fortunate to have data of 100 folks going back to being admitted in the 80s to being admitted last year, it's the lowest end of our pay scale. We have medians per class. We can slice and dice this volume of data. I would suggest that right now it is a huge benefit to have this volume of AAGs, this volume of lawyers being treated exactly the same for salary purposes. With collective bargaining, that could change because we necessarily have to exclude some AAGs from collective bargaining because they are across from the union or they do general counseling
Right.
that might involve the union.
We heard that testimony last week that there would be 5, I think, excluded.
So if I can, I'd love to correct that. Yeah. So it's more than 5. I didn't mean to interrupt.
Well, that's fine.
But I think there was discussion about there may be 5 AAGs who handle grievances at the labor board, and that is correct. But labor and employment cases are outside the labor board. And I'll just give an example of a case that the civil division, and I think the committee has heard from a representative of the civil division. The civil division handles a variety of state defense matters, including in Superior Court, in federal court, in the Supreme Court. So there was a grievance at the labor board where a department had terminated the employment. This is a public case. It's been in the press, public Vermont Supreme Court decision. A department had terminated the employment of a classified employee when that employee made some statements that the Department of Corrections felt were contrary to state policy and were grounds for termination. And these had to do with comments about smelling fried chicken when this was a white supervisor making comments to a Black subordinate. So the white supervisor says he smells fried chicken when this person is heating up their lunch. They say there's no fried chicken in my lunch. Department of Corrections says, you know what, this is not what we want for a supervisor at the Department of Corrections. We're terminating this employment. The employee represented by the union challenged that termination, and the labor board held that was a wrongful termination. The civil division handled the appeal. So the department wanted another bite at the apple, saying, okay, I really want to make sure we have this right. Really, we can't let this person go in these circumstances. And the Supreme Court, in a split decision, upheld it. The civil division, not the 4 folks handling grievances at the labor board, handled that case. The civil division has handled other cases where labor practices are challenged as potentially discriminatory. So a couple of years ago now, a group of female employees sued the state for a practice known as hire into range, where someone will be brought in at a salary above that of their peers, and then you carry that salary across the positions you may move into as you move into other jobs. The civil division defended the state against a claim that that practice violated equal pay and other fair employment practices law. The civil division has handled labor cases in federal court. The civil division might handle the public records litigation that the union may have. So if we go down to the bottom here, I tried to identify.
So sorry, just to finish the number, it would be more than 5 that would be excluded.
I've tried to identify it in section 3 at the bottom of the
Okay,
page
right.
there. So we've got 9 AAGs, excluding the chief and the civil division, who all handle defensive matters. We've got the roughly 4 or 5 in the unit that handles cases with the Labor Relations Board. We're actually about to have some vacancies there, so that right now we're able to assign those cases outside of that unit, including the other parts of the office. So then when we have that influx of defensive cases, again, this is the non-discretionary work of our office. We have to defend the state when it is sued. We have 5 to 10 AAGs outside of the civil division also handling defense of the state. We also have lawyers who are the only source of legal services in their agency. So that's essentially, you got to handle whatever comes in the door. And that might be advising on something adverse to the union or something related to labor and employment. We're talking about 6 AAGs at the Agency of Transportation, 6 at tax, EGS. And then again, as these questions come into the office, we can assign them right now across members of the office, and in the context of collective bargaining, that would change. So it is
So it's really more like
more.
20 to 30 that would be excluded.
That's my understanding. So again,
Sorry.
Keisha,
Because we're so short on time,
we are.
I don't know if you know,
We need
I
to
don't
get
know what we're gonna do to answer all these questions. Maybe that happens outside of committee, but I will just say, I'm personally ready to vote on this question because it took a lot of courage, I think, for one AAG to come forward and say, you know what, I'm toward the end of my career. I can take some kind of, reputational risk to bring this issue forward. It is going to be extremely hard for other AAGs to do anything public to advocate for their position in the legislature. And for that reason alone, it feels like the VLRB is a much safer place to have a meaningful discussion. I always think of the problems that exist when we try to solve things legislatively, not necessarily the benefits.
I appreciate that.
So I think, honestly, the more you're saying, the more strongly I feel about the VLRB.
Yeah, if I can, the folks at the lowest end of our pay scale are not in AGO position numbers.
Right.
So we have to address this question of how to bring AHS to the table.
Okay.
So if we flip to the back, again, we have
and then we are going to have to shift to Al.
Sure. So, and we regularly hire from private practice. I know there isn't the time to talk about the difference in private practice and the quality of life at the AGO. I would hope that the committee appreciates that we want to offer collective bargaining in the least disruptive manner possible. So if our focus is the 10 AAGs who make less than $80,000, we need to figure out how to bring AHS to the table because that's where a lot of those AAGs reside.
Because I understand the average pay is 118 or something.
Correct.
118,
It goes up every single year. So they go up because of merit increases, promotions. So these are always moving targets. We are approaching $120,000 as the median salary, including the low-level managers, directors. For the AAGs with no managerial responsibility at all, we're close to 115. Costs are 181. So we're very transparent about that. When we ask for a new position, which we are doing right now at House and Senate approves, the median annual cost of an AAG salary and benefits is $181,000.
So can you propose something? I mean, can you work with VSEA on something that brings AHS to the table?
Well, this is where we need to come up with possibly a new joint employer model of having the attorney general and the governor. And I don't know of that model in any other states to answer.
I just don't know that we're going to resolve it well.
I'm not sure we're going to resolve it necessarily this week. So, but I mean, we may, but
It's very unlikely.
it's
There are, the more I look at this, the more questions asked. I could spend a day asking questions and still not have all the
Right.
answers. I'm very concerned about potential conflict of interest. I'm very concerned about increased costs. I'm very concerned about duplication of services because things have to be split up. This is, and to rush it on a clock like this isn't going to
we're
work.
not rushing it. We're further discussing it so that we can consider whether we're going to do an amendment now or whether we will hold it, discuss it further during the course of between now and what we want to do with it additionally. So,
If I can
I
make
think-
one more point.
Yeah, and then we
I'm
need to
sorry.
pivot to
Yes,
Al.
I so understand.
right.
Right now, there is no law that requires agencies to employ AAGs. So worst case scenario of results of this possible new structure would be agencies decide to just convert AAG positions into non-AAG.
And why is that a problem? I guess that is what I'm not fully
So
appreciating.
then you take them out of the Attorney General's office entirely. So they are just an in-house lawyer. So they have nothing to do. So they would have nothing to do with
So they
collective
wouldn't
bargaining
be-
of AAGs, unless you want to provide collective bargaining for all lawyers in the executive branch. Then you would avoid that issue. But an agency head or an elected official, folks who've recently done this, may decide, you know what, I like this person. I don't necessarily want the connection with the Attorney General's office. I don't want this sort of dual model. So I'm just going to make them my lawyer, my in-house lawyer. And there is no law that governs any of that right now. So the Agency of Human Services potentially could decide, you know what, we're going to flip these positions to be like our in-house lawyers. And AHS has folks sitting side by side, in-house lawyers and AAGs, and there is some overlap in the work. So I so appreciate the committee's attention to our office. It's an outstanding office.
And we appreciate that. And we also are big supporters of the right to collectively bargain. And it sounds like there are some challenges which you voiced, but I'd love to pivot to Al Gordon, who's with us. And thank you, Sarah, very much. This is helpful.
Thank you
This
for
is
your time.
very helpful as we continue this discussion. Al, would you be kind enough to join us? And then we're going to, Dick, we're running a tiny bit behind because we were on the floor for a little longer. So we're going to give this a little bit. Please hold back 11 minutes.
Good morning.
Good morning.
It's good to see you all again. Happy to be here in person. I'm up from my office in Brattleboro today.
Thank you.
Pleasure. To talk about something that's important to me personally, important to the union movement, and I think important to the people of the state of Vermont, is that we treat all workers as best as we can as workers with all the same rights that all workers have. As I listened to Sarah's presentation and the concerns that she brings on behalf of the Attorney General, one thing I'd like to knock out of the way right away is that the statute about compensation says that the Attorney General shall fix the compensation with the approval of the governor. I don't believe the governor actually approves each and every Attorney General, Assistant Attorney General salary, right? The governor approves perhaps a range. The governor perhaps has approved the salary scale, the pay scale. But the thing that is missing here, the fact that there is a pay scale means that it can be bargained. Right? There's already a scale that exists in the universe that all of the assistant attorneys general are on. Maybe the scale needs to be tweaked. That can be done in collective bargaining. Maybe it needs to go up. Maybe it needs to go down. But this is not about having every single person paid exactly the same amount of money. That's not how it works. If you look at your non-management bargaining unit, it's huge. There are significant differences in pay and benefits between the sworn law enforcement personnel in Fish and Wildlife and the nurses who work in the psychiatric facilities and the groundskeepers who keep the State House looking beautiful, right?
We're clear on that. It's unclear to me that after that testimony from Sarah London, that the lowest paid assistant AGs that are in the AHS office would actually be affected by this.
Well, collective bargaining would potentially impact pay for all employees, but it would depend on collective bargaining. It would depend on if a union was elected, sitting across the table from the Attorney General to talk about whether the salary or the part of the pay scale that those employees are sitting on is appropriate. And it would obviously move it. But I caution you to get too caught up on pay because this is it's not really about pay. Pay is certainly one issue that employees are interested in. But as I think Todd Delos told you last week, pay is really not the primary motivator of most people who come into work as a government lawyer. I worked as a government lawyer for a number of years, and it wasn't about the pay, it was about the time off and the benefits and the ability to spend more time with my family as opposed to private practice.
But we've also heard testimony that the AG's office is actually a very good place to work with all of those aspects. I guess a question I think all of us have is how many other states have this right to collectively bargain for AAGs? I think it's only 2. And
I'm sorry, did
is it more than 2? And what's the experience of those states? Because I think that's what was one of our big questions that I think we.
So off the top of my head, I know of 4 where the attorney generals are actually organized and can think of a handful of others without having looked into it where they have the right to organize, but just haven't chosen to do so yet.
Mhm.
So Connecticut, Washington, California, Oregon, they all have actually unionized attorney generals.
So Connecticut, Washington, Oregon.
In California. I'm thinking of, I think New Jersey had the right to organize, but they haven't yet. I believe Illinois had the right to organize, but they haven't. And these are just because the way employee is defined under the labor relations statute, which just happens to include people who work in the attorney general's office. And those statutes are really, in some ways, each one is its own historical anomaly. When the statute was originally passed, certain positions were included and excluded. In my home state of Massachusetts, none of the constitutional officers have collective bargaining. So our auditor, our treasurer, our attorney general, our secretary of state, that's just how the statute was drafted.
Randy, did you?
No, I got
Specifications.
So correct me if I'm wrong. if we set this ability to organize in motion, it's going to take months. It's going to probably be active next legislative session. Should we realize we needed better parameters to help guide decisions in some way to ensure the lowest paid folks are at the table.
Right.
But this enabling language is not going to do anything right away. It's going to give people the opportunity to have constructive conversations about how to organize. In that context, and you can respond to me, but I'll just make my point now and then you can tell me if I'm wrong. The best use of our time is a decision about whether or not they should have that opportunity. And us trying to do the rest of it is us trying to write labor rules and regulations that we have always left to people who know way more about this than we do. This would, in my mind, be outside of our scope, just like many other, very internal rules and regulations that we expect of those who are here year round. So tell me if I'm wrong.
You are not wrong. And to answer sort of the embedded question in there, the first thing that I think is a fallacy is that we're talking about and this whole process as if there were a single unit of assistant attorneys general across the state. That's not what you're creating by the statute. You're creating the right to organize. The AAGs may come in seeking a single unit. They may come in, maybe just the lawyers and human services come in to take a small unit. But these are the questions best left for your labor board, who will determine in the first instance whether there is significant enough community of interest across the entire petition for unit. And that will get into questions of who can bargain what. When we first did, for example, when the union first filed petitions to represent the deputy state's attorneys, and those were filed in each individual deputy state attorney's office because that's the way it was organized. And the VLRB put its best foot forward and figured out whether there could be organizing and the extent of organizing. And that's what would happen here. We are not talking about upending the entire AG structure. I will not disagree with Sarah that there will be a number of excluded people, bigger than 5, for sure. The people who we see at the labor board are not the people who I argue against at the Supreme Court. That's not how that works. They're a different group, but those different groups can come out without a problem.
The question that comes to my mind immediately is how much flux will there be between various groups, depending upon the circumstances, the cases, the issues, the organizations being involved? I almost picture a sea of moving parts here, in which you are involved in things in which you could be in a bargaining unit today and tomorrow with a particular piece of litigation, a case, an issue, the department's involved, and so on. You could be in conflict of interest. And it's that whole issue of conflict of interest that concerns me the most about this.
Well, so what the labor board would do on a case by case, literally unit by unit basis, is look to see whether historically those employees have ever had involvement. We keep going back to the AHS employees. The people embedded in AHS never get involved in labor matters. They don't go to the labor board. They don't do civil cases in front of the superior courts. There's no reason to exclude them. But there would be a group who report directly to the Attorney General in her, whether she calls it a civil division or a government operations division, who may be called upon to represent the labor board, to represent the administration in labor matters. That group could obviously be excluded, but we look at the historical pattern. And anyone who has been involved in that sort of thing would necessarily
It's
be
always
out.
a first time, I guess, is a question. And how often are there first times in the kind of litigation that the state gets involved in, or issues that the state gets involved in which there can be a flux between that department that never needed that function before and needs it today?
Well, when there are changes in assignments of work, when an agency organizes or reorganizes and it puts someone in conflict, what happens is you have a clarification of unit. The Vermont Labor Relations Board hears clarification petitions all the time when someone's job duties have changed or functions have changed. And again, I don't need to oversimplify it, but in my mind, it is rather simple. That's the expert agency to determine it. And as much as things change all the time, there's also nothing new under the sun. We've seen this kind of arguments over and over again, and we look at path being prologue. What does the history look like? At the end of the day, the conflict of interest question would be decided by the labor
By the
relations
LRB.
board. who is the
In
employer?
a timely enough fashion, presumably.
Sure, the
Now
VLR,
that we're hopefully giving them another lawyer.
the VLRB does push
Yeah, seriously.
representation matters to the front of the pile. They're not going to let that sit because they know someone's right to organize is at stake. But it would be a deliberative process with exchange of information and testimony before the board.
I'd like to get a little more comfort about that.
Sure.
Thomas.
So I'm of a similar mindset around Hinsdale. This just allows them to organize. It doesn't force a union to happen. And if anybody can figure out this ambiguity, I think it's a bunch of these lawyers. So I think it'd be fine
Well,
there.
and the VLRB, right?
But
But they have a real interest in protecting their integrity in a case where they would not want to be accused of a
Having
crime.
served on a law school board, I can tell you, having a group of lawyers trying to decide something takes forever.
Well, maybe a legislator.
You'll get it right.
Okay,
But my question is, so this is a statewide elected role, and I get the possible concern about having them report to the governor and not the duly elected attorney general. My question is, the Secretary of State's office, Doug Hopper's auditor's office, do they have unionized employees?
Yes.
As this is a precedent for, how would you compare this to that?
It's much the same.
Okay.
And even if you think about, it's silly, you think about the judiciary as well. Where does the judiciary get its budget, right? The governor puts a budget in, the legislature looks at it, passes a budget, gives the judiciary the money to spend on the positions that they're going to spend. Every part and branch of government, every elected official, every appointed judge sits underneath a budget that you all will pass based on conversations with the governor. It does not change who the employer is. The attorney general still has the power to appoint attorneys general and fix their compensation.
okay. So on that note, I think given our time, I would suggest we sort of get a sense of where we all are on this and whether we want to include this in an amendment on our labor bill. We have another issue. We're going to pivot to the certified payroll issue next. And those are two of the things that we're considering. So, how is the committee feeling?
I'm not feeling good about this. I think there needs to be, we're rushing to get something done and the pieces of this that I don't think have fully discussed, that we fully understand, that we have enough of a picture. I'm very interested in why other states have not done this. Perhaps you've had the opportunity to. And so I am not in favor of this section.
So I'm 99% sure this just got us directed to Senate Finance along with like 13 other bills. So my point is, I don't think that this is gonna make it to the floor until next week anyway. So if Madam Chair, if you do want to pick up your rest of your conversation, come back to it tomorrow or Thursday.
We can continue this conversation.
But we are-
Absolutely.
I support allowing the AHE speaking.
Right, but also given where we are, might consider further discussion of it. Agreed. David.
So I agree with Randy and but I fundamentally respect the fact that for this group to keep moving them towards unionization.
And I'm not saying absolute no. I'm just saying.
I hear
not
you. I
right
hear you.
now.
It's a lot and it sounds complex and I agree. I support this. I support always the right to collectively bargain. But I do think perhaps a little more conversation would help get us there. Keisha, I think I know where you stand. Or sit.
I'll just, I'll make a novel point, hopefully, perhaps, which is what I don't think will change, even if we give people more comfort, is that this should simply be one line of legislative language, that it shouldn't be so complicated that we somehow take responsibility for sorting out all of those details. This committee has always looked at the right to collectively organize as a yes or no question in a lot of ways. And I would be concerned if people started to come forward and say, it's complex and you should figure out all the details, because we are not qualified to do that.
Agreed. So in our next conversation about this, we will look at the language that we currently have with Sophie and let's do that. So
And I think the fundamental question is this group so special they should be denied the right to form different relationships in different.
right. Or is there something
department.
so particular to this group?
And
Yes.
that is one of the issues that I'm frankly
Yeah,
getting at.
I hear
is
you.
I hear a lot of indication that this is a special group.
Right.
And I would like to know what other states who have not decided not to do this.
Right.
How have they considered that? And what factors have gone into that? And what kind of arguments that we have not heard? And I'm concerned about what I haven't heard, not what I've
I
heard.
just think respectfully, that would probably be some kind of testimony that you might have to find. I mean, I don't know how you get that information.
I think in part we could get some of that from the 4 states that have done it and the ones that perhaps have chosen not to, but we can get that and have that further
Certainly,
conversation.
to identify the states that have looked at it and have not, and NCSL and CSG are places to look for that.
Right. Yes, and we can certainly get that. Let's continue this conversation. Let's pivot to the misclassification concern we have, and hence the interest in a certified payroll with those. So we're going to pivot to that, and I think we have Alex first, and then we have
I don't see
there.
Madam Chair, I was wrong.
Alex is right. Oh, you're right.
Who sent the appropriations?
I don't think it's.
So you. You 129, but you have technical corrections to DOL, and I couldn't see what the number was.
Did you want to quickly touch on decertification? That was,
Oh, I
that's why it was like bifurcated into 2. It sounds
Yeah,
like,
I thought sorry. Absolutely. We were going to talk about decert first, and then we were going to, I apologize. Our time has just gotten so contracted, whatever the right word is. Decertification. Al, I think you're back. Sophie sent us something as well. And Al, let's touch on the decertification first.
Very
Sorry,
quickly,
thank
I know
you.
your time is limited. As it relates to decertification, I would just say a couple of things. The goal of the labor relations law and the way it's structured is stability. It should be difficult to get over the burden of getting that union in, because people have to really sign a contract with that union to make sure that they want that union to be their representative. But getting out should be a true contemplated move. It would not be in the interest of the state or the union or the workers to have elections every 2 years just because someone could get a 30% people to sign a petition. And that's the distinction. When you ask to have a union election or ask to be certified by card check, you are signing a contract asking the union to be your certified representative. It's not the same when someone's seeking decert. At that point, they're just signing a petition saying, hey, I want to vote. That's a real easy thing to sign, and it shouldn't be, because what you would end up with is potentially elections every 2 years, which is different from pretty much every other state and every jurisdiction, because under Vermont law, you can only have a decertification, under anyone's law, you can only have decertification votes during the open period, which is right before contract expiration. Most jurisdictions have 3-year contract periods. Vermont has a 2-year contract period. So literally every 2 years, the union could be facing another union coming in asking to take over. The state could be looking at a new bargaining representative every 2 years. By making sure that the majority of employees actually want to take that move before the election is called, that would be the strong move to promote stability in labor relations. And I think it's in the best interest, not just of the unions, but also of the state, who has to be the collective bargaining partner on the other side.
Right. Questions for Al?
and we got a document about how this works in other states that's pretty much aligns with your testimony.
We got that, and yes, so thank you, Sophie, for sending us this. It definitely raises the bar. I think when you think about it as the majority, as opposed to just 30%, which is a minority, I think I feel much more comfortable supporting. I mean, I have supported this piece of it, but I think that's an important way to look at it, is that it's the majority of union members deciding not to continue, as opposed to just 30%. Question for you: how many do we have of these a year? And how many decertifications have we had in the last 10 years?
As general counsel of the VSEA, it seems we are facing them every 2 years in one of our units. We just had one 2 years ago in corrections. We are potentially facing another one this year just because they can. it's in
No,
my,
but they can't, it's not just because they can, they must have issues that they're on.
There's reasons for it.
well, in any group of people, 30% are disaffected in any group, particularly in the polarized world we live in right now. In any group of your constituencies, you could have been elected by a 70% margin in your constituency. That means 30% of those folks could sign a petition to have you removed from office. That's basically what we're talking about. It really is the polarized world that we live in, and making sure that the majority of employees really want to take the step to determine a change in the certified representative, which would also mean a change in the relationship between the state and the employees, which is something that really needs continuity. John Berard would also probably say he does not want to face a new union every 2 years. It would make his job impossible.
It would certainly make it harder. Further thoughts, I actually think so oddly that one word helps me feel much more comfortable.
Well, I guess the issue is if 30% is too low, and I recognize that you're right, 30% probably are disaffected most of the time, or with any decision and any vote. It's difficult when you get to taking the majority of the vote, doing it in effect in the sort of informal way that you might with a petition campaign. Some people won't speak up regardless. What if you compromised on a number like 40%? Would that make you feel more comfortable?
Personally, no, but it would be certainly better than where we are, right? I think that particularly the world we live in today is so fractured and polarized that the margins are less than they used to be. There are 30%, 40% disaffected before upending labor relations. I think you should reach a majority
I mean,
threshold.
the 51% every day, and it could be different 51%.
It's not 51% though, it's 50% plus one.
Plus
person.
one person.
I think that if we're going to continue the AHE conversation, we could consider a negotiation, because I believe that the union might be open to a negotiation on this. And we can either have that now, which I don't think we have time for, but we might come back to the table in the next day or two with a number that might work, that we could get all into agreement on. I'm fine with 50% plus one. I don't know where the rest of the committee is at the moment.
I'm fine with 50 plus 1 or 40%. I just think we should raise the threshold based on the well.
Or 45, maybe.
Sorry, my faith. I mean, I just feel like if we're gonna go through all of this, we should. It would be weird in my mind to go to the floor and say, oh, most states that do this have it 50% plus one, but
Well, 40, yeah.
we just decided we
Do you
compromised
think-
at 40%.
Remember
This-
the number on the chart there. I think that
There
there's-
there are several states that have moved to 50.
But there are some,
There's only one. Hawaii is the only one who has moved to 50%.
and other than that.
You gave us.
Oklahoma has raised the
Do you have
amount,
your
but it's
document?
not 50.
No, yeah, I
Massachusetts is at 50%. plus
So,
one.
that's
So
Sorry, what?
Massachusetts certainly is as well.
Alaska's at
That's the
30%, California's at 30%,
Yeah,
Connecticut's,
no, Hawaii
Ohio.
I mean, the majority.
are at 30. That's true. That doesn't mean
So
we want to stay
for
there.
our move to 50 is clearly outside the mainstream, isn't it?
Well, what we
By
heard,
far.
what we heard in testimony is that more states are looking at the same thing we are, because this is an area where you can really see opportunity to sow division. There are 3 states, we received information, there was 3 states that have a 50% threshold, and
Right, we
I
got
think
that.
if we're going to move up, we might as well move to where it's not
This
the
is what you
majority of the
got, right.
conversation is, which is a majority,
I saw
a
that.
simple majority.
And Madam Chair, not to speak out of turn, but Vermont is the only of these states that has this every 2-year ability to decertify. All the other states have at least a 3-year timeframe. So it's more important in Vermont, where this could happen much more frequently, to think about raising that.
Got it. Yes, got it.
Thank you.
No, I appreciate that. So we have 4 that have definitely moved to 50%. And with our 2-year window of contract window, I would propose we support the 50% plus one. But I'm curious. I think Thomas, you're good. Keisha, you're good. I'm good. David, where are you?
50 plus minutes.
Okay. Right. I think we are, Randy,
Well, I'm just looking, 30 plus 30, and I stopped the count at 30,
yeah, no,
or at 30.
but very few of them, it would be interesting to see what their window is, whether it's 3 or 4 year contract periods versus 2. Are we one of the only states with 2-year contract periods left?
I can't say that I know every state's law, but you're the only state that I know of, and I know a fair number of states systems.
Again, here we go again. We're making decisions on things that we don't know anything of. We don't know.
No,
I'm
no,
looking at a list there of 20 plus states that are 30%, and we're saying we got to move it right away. And then we ask, well, who else is doing this? And we don't know.
I'm not as worried about other states on this one.
Yeah.
Like, I don't know why. This seems like the logic stands. And we have almost, I think, 9 or 10 states that are enshrined right to work states. We have lots of configurations around the country. I on the merits of this, I support it. I don't need to know what other states.
I do too. And on the majority, on the 2-year and on the majority need, I think it needs to have a majority of people to decide to decertify. So, I think at the moment,
The
I think
majority isn't certified, as I understand it. What the majority
decertify.
is to decertify. The majority, in terms of collecting, whether it be 30% or 31 or 40 or 42%, that's just to have an election, isn't it?
Yeah.
Period.
It is
You're not
to
going
get
to certify
across- yeah.
anything
Right.
until the election is held.
Right.
And so there's still a majority rules. But the notion of being able to raise an issue so that it gets voted on, that to me is something that, a large minority ought to be able to do. Now that, whether that's 30% may be too low, because as you mentioned, and in my experience, 30% are always mad about something, but to raise that to something like 40% strikes me as reasonable, because you're not, the amount to be able to get to that 50 is a very difficult hurdle.
I would suggest we continue the discussion, because and even though I think I think we have strong support for 50 plus 1. Let's keep it open for the moment. I think we have a straw poll vote on it at the moment for 1, or just 4, and it's unclear where Randy's going to 4.5. Right. So let's thank you very much, Al.
My pleasure. Good to see you all.
That was helpful. That was helpful. And I think we're now going to pivot to the certified payroll, the misclassification concern that many of us have. And I think to start, we're going to start with Alex, and then we have Dick is here as well. So we have Richard Wabi and Alex Potvin. Alex, you've testified already on this issue, but come join us again. And we heard great testimony last week on this as well. So our hope is in the next day or two to come into agreement on what we might include in this amendment, and I think we're getting towards some agreement on most of these. Okay. Alex, and then we'll have Dick join us.
Sounds good.
Great.
So good morning. For those who don't know me, my name's Alex Potvin. I'm a 20-year member of Local 693 and officer of the local union as well. We're the plumbers and pipe fitters here in Vermont. I'm here to offer some more testimony in support of the labor bill 250652, paragraph G more specifically, which is now S125, I guess.
Well, it's actually not in our bill yet. We
Okay.
would be putting it in if we chose to include it.
So more specifically, I wanted to address some of the concerns we heard from various department heads in opposition last Thursday. A point was raised about additional strain on contractors. All contractors who participate in federal Davis-Bacon work are already compelled to abide by these requirements for certified payroll. These records are maintained by the contractors, so it would be business as usual for them. I'll also be submitting, I think you have now, signed letters from contractors who are in support of these amendments. They, along with myself, we also believe that it would not be a burden, but also a benefit to the state to ensure the integrity and responsible spending of these taxpayer dollars that go towards these construction projects. As to the point made about additional costs to the contractors for the bidding process, yeah, bidding is expensive, but it's expensive whether you're bidding private construction or public construction work. One additional task of maintaining and submitting certified payroll would hardly be a financial hardship. As I've already stated, these are steps they're all familiar with. If a contractor is deterred from bidding because of having to follow these rules to ensure proper classification and appropriate wage allocation, then we need to ask ourselves, is this the type of contractor that we should be giving taxpayer dollars to in the first place? A point was made that the state would not begin to know how to maintain these records. To this, I would say that could be easily rectified by conversing with neighboring states to see their process for it. It's not a unique circumstance to have to follow. Or better yet, the state could look within its own AOT's office to see their process for maintaining the records. Currently following this practice for all highway construction work. A question was asked last week, what do we hope to accomplish with this? This being the draft that I'm referring to. Our intended purpose of this would be to ensure the proper classification of all trades workers in a much more immediate nature than when these workers file their taxes at the end of the year. As well as making sure that these workers are being paid the wage that would correspond to their classification. Another point was raised that the most common misclassification that that is seen with workers is a worker being classified as a 1099 employee as opposed to when they should be a W-2 employee. I can speak firsthand, as I stated in my first testimony I gave on February 27th, that this is not the only cause for concern. A worker being taken advantage of on a construction project right in the DOL's office to the tune of about $2,400 over the course of a month would be an example that I gave you. This is a different type of misclassification than what is typically handled by the DOL, but from my experience, not unique to this individual, and also not the first time this contractor has been in violation of the exact type of violation. Classifying someone as a helper instead of a journey person, as well as not paying them the required fringe benefit addition in order to pay them a lower wage, is wage theft at its lowest form. And also robbing this individual of their education and apprenticeship hours that will go along with it. So to not have any of these situations arise, that's what we hope to accomplish. So I'm brief today. That's all I've got for you, but I'm happy to answer
Great,
questions.
thank you. And Judy was, Judy DeRoche was very good on how simply and straightforwardly this is done with AOT.
Correct.
Thomas.
Would you contend or put forward that you think that this wage theft and the misclassification is happening frequently and intentionally right now?
I mean, I'm one trade, and within the last 2 years, I've come across personally 2 individuals in my respective trade that have been misclassified, not being paid the fringe benefit attachment, not being a registered apprentice. So in that case, they should be being paid the journeyman's wage, which they are not.
So who misclassified them?
I don't know if I should.
No, I mean, not a company name.
I see.
The
It would be the contractor they're working for that is required to report their
intentional or
I would say intentional. Yeah, I mean, in the most recent instance that I had, it was definitely intentional.
Is there any enforcement mechanism to pick things like this up, such as reporting by the individual who is being shorted or someone else?
There is. The state has a process for wage and hour violations on the DOL's website currently. So the last individual that I worked with from going through the process with him, it was very it was pretty cumbersome. It's confusing. And to be totally honest with you, 21-year-old person who is just starting out in the trades they don't know these rules. They don't know these laws. They're not versed in it like, like we may be.
It's
So-
not their job, it's the employer's job to make sure
Correct.
that everyone is
Correct.
classified appropriately and certified that their payroll is what it is to be.
But typically speaking, if there's any kind of enforcement mechanism or a reporting mechanism, there's an opportunity to make someone aware of it, and then in that case, that someone should do something about it. Is your experience that even if reported, it isn't fixed or remediated?
So this past instance, it was, and it was alleviated almost too quickly, which tells me that the contractor knew damn well what they were doing. In a lot of instances though, people are almost scared to come forward for retaliation from the contractors that they're working for. Because there's people who are being paid
Right.
not a ton of money to begin with. I think we can all agree trades workers aren't really that well paid for the most part.
Well, increasingly well paid. I mean,
It's getting better. It's getting better. If you own the company, it's definitely a lot better. But so they don't want to put their neck on the line and make these reports. This individual was actually fired by the company, so he was more than willing to go forward and make this.
so only, David,
Does Davis Bacon have like a scale that requires reporting? Because you say that already requires compliance in certain areas. But does that like start at a certain threshold and above, or is it?
No. So if a job falls under Davis Bacon requirements, then all the certified payroll stuff all follows it hand in hand with it.
and in every other state is required.
Correct. So
It's required.
yeah, so Mass, Maine, Connecticut, Rhode Island, New York, all of our northeastern states, they all require certified payroll, not only for Davis Bacon, obviously, but for their state prevailing wage work as well. New Hampshire is the only state in our area that doesn't even have a state prevailing wage laws. So,
Why are we not surprised? Alex, thank you. Any
course.
other questions? Right, then, thank you very
Appreciate
much
your
for coming back.
time.
No,
Thank
we
you very much.
appreciate your time on this and thank you for your testimony.
of course.
Richard Robbie, welcome. Come join
Hey
us.
guys,
Good to see you.
I rarely stop in this house.
It's a very welcoming house.
Richard Waddle.
We've been-
So we're gonna
Associates General Contract.
introduce ourselves.
You're fine.
I'm not sure everybody's met you.
We've met Tom
Okay.
Chitney.
Tom Chittenden, you know Keisha, Allison Clarkson,
You know me?
Yes,
8 weeks, right?
Richard, welcome.
thank you. I'm not sure why I'm here. I'm not sure
Well, Sarah thought you
What
would
we're
add to
actually-
the
what
conversation.
you're actually talking about, but I will tell you, I do not watch Seinfeld.
Neither do I, but we were on a Seinfeld episode
Okay.
the other day.
What I understand, I'm supposed to speak of certified payrolls.
Right.
The way the bill presently looks, I'm not sure what we're trying to accomplish. I don't see where a certified payroll plays into this bill. Because as I last read it, I did not see prevailing wage written in there.
This is a draft. We had not included it in our bill 125.
Correct.
So it is in a draft that does address prevailing wage. The draft of the bill is 652 and it has a whole section on prevailing wage, which we decided not to move on, but we thought we might be able to move on this section G, which does require that the state use certified payroll with their Davis Bacon contracts.
Presently, the state is so let's start again. I have 17,000 employees that the construction industry employs. Of that, only 5% are unionized in the construction industry. From that piece, we have somewhere in the neighborhood of 1,000 registered contractors through OPR. When we look at that, you presently have 50 to 75 contractors bidding on V-Trans projects. From that 1,000, you have 15 right now that are GCs bidding on projects for VGS doing state work. You have another 75 or so that are specialty contractors in there. If you want to limit the number of contractors doing business with the state, certified payments, put in prevailing wage, because all you'll see is that they can't afford it. And they can't afford the regulation and the regulations and the restrictions that are put on them. They can't do it. It's the one-man operations, the two-man independents, the subcontractors and the contractors. They'll just back down. And I work with the 2- and 3-man operations as well as the 100-man operations. And I see what's happening. Presently, we're 1,700 people short in our workforce. We're short. Everybody's being paid a fair wage. You want to talk 3 years from now, when the bottom falls out of this can, then you may need to help them. But today, everybody's being paid a fair wage for a fair day's work. And I think we're trying to answer a problem that doesn't exist today. I
Thank
can
you.
tell you one last thing, that if we go through with it, you will see higher labor costs instituted. You will see them. You will get less bang for your buck. You will see inflated project costs in the bidding process because, again, trying to figure out what this thing is and where people are going to be working. You will see reduced competition, which gives you a higher price for your work versus a lower price. A study was done by the McCain Center, and they found that certified payrolls and prevailing wage laws increased the average cost of construction by about 15%. It's what's out there. Go ahead.
Thank you, Dave. I can't help but notice you have Sarah here who's been with the committee, through a lot of it. And I think our chair tried to underscore this, but we have moved away from changing any of the prevailing wage laws that we have on our book in this bill. But we do have a prevailing wage law for state funded projects. So the only piece that we would be changing is requiring the certified payroll for those.
Right.
And right now that already exists at AOT, right?
It
So
exists on any Davis-Bacon project
Right.
that have federal funding or federal assistance.
right. So I think it doesn't sound like a huge additional burden to, I really like that top 5 basic.
Thank you.
It's flat, it's great. The question I have is, my sense of why we would do this is because it's just it's security that, we have some level of oversight on the projects that we give state money for.
If it's worth 15% to you,
Would, so can you separate that figure by the certified payroll versus the prevailing wage? Because if it went up by 15% just based on certified payroll, that would probably mean that people are reclassifying.
No, I'll tell you what it
Exactly.
is.
That's which is
Yeah.
what
I'll
our
tell you what
concern.
it is. Randy and I are contractors. I'm not we're together. We're a subcontractor for somebody. We are not gonna have the manpower to put together a certified payroll, so I'm not gonna bid on the project. These two work for a larger group, and they're gonna turn around and put that bid in, knowing that we can get top dollar for this.
Can
And
you,
you will
Our
pay.
competition has been
but
reduced.
you're the
That's correct.
expert, can you speak to what the burden is with a certified
Yeah.
payroll because, everybody should have a good bookkeeper, right? Like, what's
Yeah, but
the,
it's not just a good,
And no one should be misclassified. I think our concern is misclassification.
so
And
you're promoting unionization.
no, I'm
Yes, that's what
promoting.
you're doing right now,
I support unions, but I am not supporting it at this very moment.
but you
What
are.
we're supporting
The
is
minute you
people.
say they're misclassified, you are.
I am trying to
Go ahead.
reduce misclassification. I think that people need to be identified for the jobs they are working on when they're working for Davis Bacon with federal money and our taxpayer dollars.
Sure.
They need to be paid what the employer has said they're going to be paid. We need to make sure they're being paid that wage. That is what I mean by making sure they're classified correctly.
What's being done in that Davis Bacon and you're.
No, it's not being done in this state. It's done in Massachusetts, Maine, New York. It's done in other Davis Bacon states. It's not being done here, and we would like to have it done here. I mean, some of us would like to have it done here. AOT already requires it. BGS is the only one that doesn't at the moment. So it's a very narrow little.
BGS has to require it on any federal or federal assistance programs. All we're talking about is you are now going to require it on the window replacer. You're now going to require it for me and for right.
Thomas.
Can you elaborate on the question I heard Senator Hinsdale for the two-person job, the two-person company? What is the burden of this classification? Like really contextualize that for me.
No, it is the bookkeeping, the submission, the wage and out. Randy may be right now, maybe a painter. I'm paying him 25 or 30 bucks an hour to paint. I may need help sheetrocking tomorrow. He's still going to get his 25 or 30 bucks and he's going to do sheetrocking. Now, when you start looking at prevailing wage, that sheetrocker, it may work in my favor. That sheetrocker may only get 22.
Drop it down.
Right?
Yep.
And now I've got to resubmit and certify a payroll that shifts during that week for those smaller contractors. Right now, what a smaller contractor is just keeping track of Randy working day by day, 8 hours here, 10 hours there, 3 hours there, not keeping track of 3 hours sheetrocking, 2.5 hours of painting and whatnot. Randy's just on the payroll. And it's not just 2-man operations. This could be a 10 or 12-man operation because again, we're talking a bookkeeper who is probably also an office administrator. It's just one of those jobs because they aren't classified either, right? We're all trying to get the work done.
But if they are a contractor who is working at the level of the Davis Bacon contract, they are operating at a level where they should be able to manage keeping track of their payroll. They pay the IRS, they have to keep track of their payroll, they have to pay the Department of Taxes.
Which explains why you have 1,000 contractors registered with OPR and you only have 15 of them working for BGS and you only have 50 to 75 working for AOT. That's all you have. That's less than 10% of the total contractors out there attempting to do work for the state.
I will just say, when I was on GovOps, and maybe you can take this to GovOps in the afternoon, I completely agree with you that we put too many burdens in place for folks to become preferred vendors or to contract with the state. People have come to me in immigrant businesses, wherever, and said, I was just dropped as the vendor from the state, getting notices about contracts, and I don't know why, and it took us months to get back on there. That actually seems related to the concern that we got from BGS that they wouldn't even know what to do with these records. I think there's a bigger problem with BGS being the funnel for all of these contracts and how well they're maintaining and managing and cultivating those relationships.
I don't think so. I'll tell you why. We have tried for the last 6 months to increase that number, that 15 number. We've tried, we've offered training on how to fill out the forms. We've offered people help in filling out those forms.
You should have led with that.
No, we do
Yeah,
it, right?
good.
When I
That's
forget
good.
what
Thank
we
you for doing that.
and understand, I forget what we do. We have been recognized nationally
Yeah.
7 times in the last 5 years for
Congratulations.
for our work that we do in and with contractors in the state of Vermont.
Mhm.
Part of it is we step out of our comfort zone and try to build other things, right?
Mhm.
And that's one of those pieces we tried. Out of that mix, we've had 4 new
Mhm.
contractors actually go through the process to register within the
Oh, yeah.
state contracting, not OPR, the state contracting requirements that oversee BGS, ANR, that
Oh,
whole
DOT.
group, right?
So what's the moment where they get up and walk out of the meeting and say, "Oh, we have to do that"? We're out.
Why is this?
You need to fill all these papers out, submit them, have somebody review and go through your history. That's the moment.
Well,
And we can go through all the PowerPoints, we can go through all types of things.
But But the bid on
Careful,
the
I'll leave
Davis
with them.
Bacon project, you have to do some of those. This is.
That's correct.
federal.
Pre-qual, but
What we're talking,
you're-
but this is just certified payroll we're talking about.
Right.
Why is that such
But
an
no, you
additional?
aren't. You're talking about a whole mix here. It's not just certified payroll. In order to have certified payroll, you gotta have Davis Bacon. In order to have Davis Bacon, you end up with prevailing wage over here. And what we end up doing is creating this regulatory roadblock.
But we're there
and
already. Dick.
resistance.
We're there already. We already have prevailing wage. So if a contract's gonna bid on it, even if it's a small person cut, so even more, I have a question, which is if it's a small operation and you only have 2 or 3 employees, that isn't that hard to keep track and certify 2 or 3 employees.
No, you're wrong. I'm sorry, man. You're wrong. It's hard enough to keep those 2 or 3 employees coming to work every day. One more burden on their back. It's all it is. It's explained very clearly in the numbers. When you have 1,000 contractors registered at OPR and you only had 15 of them doing BGS work, general BGS work, you have a total of 100 specialty contractors.
I think residents were also late payers. There's problems
so add
working
up-
with the state.
Yeah, so
I mean,
I will agree with you. There's other problems,
yeah.
but we're just adding another one.
Well,
Let's put another one in there. See how
Right,
many
but-
people we can reduce this number by.
let's get a small contractor in maybe to have this conversation with us. Because we share the same goal. We
I'm not
want,
sure.
okay, well, I'll tell you what the goal is and you tell me if we
Yeah,
share. We want more small and medium-sized contractors to feel good about doing business with the state.
Remove the regulatory and the regulatory and restrictiveness of doing business with the state. And you'll have more contractors. Until you remove that, you're just gonna raise, AOT will tell you this right now. As a matter of fact, you had 3 pavers testifying in front of the transportation committee at one point, and they were complaining that we did 30% less paving last year than we did the year before because we ran out of money. Why'd you run out of money? Because there's only a limited number of people that can address that. As long as you keep limiting the number of contractors that can do your work, you will pay top dollar. Until you open the doors, it's not gonna happen.
On that note, we have to end.
I know.
We're now after time. I appreciate you coming in, Dick. Thank you very much. And yeah, we will continue this conversation clearly. And thank you all for. Thank
Those
you.
are my members. If you would like somebody else, Sarah will certainly get
Great.
in touch with them,
Well,
and I'm happy to be